Hello, hello, hello.
Hey, Alan, can you hear me?
I sure can.
Wonderful.
How are you
Can
doing?
you see me?
I can see you.
Awesome. I'm great. How are you?
Good. Good, good, good. Lots going on. It's great.
Yeah,
How's business?
what's new in the world of
The biggest thing is it's just this lack of inventory. So like listings are gold right now. So I just picked up another listing yet last week. I'm gonna list it next week.
yeah,
That's because there's just so many buyers right now. It's great to have listings. So
well, that's wonderful. Yeah, I'm glad you have some. Where are you getting your listings?
So the last two I got were past clients. One of them is moving out of state, and the other one wants to upgrade from a condo to a house.
Yeah, okay. Good. Well, yeah, I haven't had any clients pass away recently, but
Come on, get on that, David.
there's potentially another one in Tooele.
Oh yeah,
So if that's of any interest to you, I can,
it 100% is.
yeah, okay. There's a gal who I'm working with her. Her dad was on the deed and
Hmm.
he died 4 years ago. And mom passed away just last month.
Hmm.
The house was never transferred from dad to mom. And so dad's
Oh,
name's still on title. And so we've got to go to court and get him off of that and get it over to my client, the daughter.
that's a great example to kind of use in this meeting. I think just to
Yeah,
like kind of help people
yeah,
understand
it's
it.
the
Yeah.
deal. And I'm not sure what she wants to do with the house yet, but if she's at all interested in selling, then I'll connect you with her and
Oh, I really appreciate that.
we
Thank
can
you.
talk. Because I believe, I don't think she lives there. Well, maybe she still lives there, but anyway, we'll
Okay.
find out.
Yeah, sounds great. So you are talking to a bunch of realtors, which means we're always 5 minutes late. So I anticipate people will start like straddling in here, straggling in.
No worries. Um, I'm going to reset my PowerPoint.
Sure.
So we'll start at the beginning. Okay. It is ready to go.
Okay, let's
There we go.
mm-hmm. You
Oh,
guys planning any trips anytime soon?
so my wife and I, we just had our 30th anniversary.
Oh, congratulations. That's wonderful.
Thank you. Yeah. Um, and we went down to Cancun and Playa
Mm,
del Carmen. Do you know
nice.
that area?
I've never been down there, no.
It was wonderful.
Yeah.
Good. It's a good time of year. It's not too hot. The weather was just almost perfect. It rained one day for a good part of the afternoon, but other than that, it was sunny and just really pleasant.
It's really nice.
Yeah, so we were there for 6 days.
That's great.
It's kind of hard to come home.
I can imagine. Yeah, we booked a trip to Puerto Vallarta on the west coast of Mexico for the end of May. So that's kind of I just keep thinking, just get to the end of May. just get there and get on a vacation.
Yeah, yeah. We always need something to look forward to.
Exactly. Yep.
Do you guys like to travel?
We do, yeah. We certainly did quite a bit before COVID. So yeah, I wanted to go. I mean, I don't really consider Mexico international anymore because I've gone there so many times and it's kind of our next door neighbor. But we really want to go. We went to Europe back in 2016 for a couple of weeks. That was a lot of fun. Would love to go back and see maybe like Spain and Italy. We spent our time in the Netherlands and in France that time. So it'd be fun to explore some other parts of it.
Oh, I haven't been to Europe. I've been to England and Ireland, but never over to the mainland, or whatever the Europeans call Europe.
Yeah, I went to London a couple times in 2016 for work, and man, that's a great town.
Isn't London fantastic? I mean, there's so much to see, the history there.
Yeah. Someone explained to me like the reason that London's so incredible is that unlike the States where like New York is a financial hub and LA is an entertainment hub and like Seattle's a technology hub, everything is in London. Like so it's like every industry has its headquarters in London. So that makes it for a really dynamic place. Yeah.
Yeah, I think so. It's very, very international. Our daughter's living there right now. Her husband's finishing up
nice.
Business school.
That's really cool.
And we've really been wanting to go see them, but they've been on a pretty tight lockdown.
Oh yeah, where are they in London itself, or are they in like a?
Yeah, they're right in London.
Yeah,
by Hyde Park.
Yeah, it seems like those big European cities are not messing around when it comes to this COVID stuff. Like
they're
much
very
stricter than we are. Yeah.
But England's doing really good on their vaccination program, and so.
Oh, very good.
And I got my first shot. So hopefully, maybe.
Did you have any kind of adverse reaction to it or anything like that?
No, not at all. No.
Hey, Ashley.
Yeah, I'm here.
So I think it's kind of strange that no one's joined, and I'm worried that maybe the front desk sent out the wrong link. Would you mind just running over and checking with them, or?
Yes, I will run over and do that. I did send David the same link that I posted on the Facebook page. So if it worked for him, I would hope that it's working for other people if they use that. But
they send out an email with a link themselves, and I'm just concerned that they sent out the wrong link. Because you're right, I used the one on Facebook; it works just fine. So
okay, I'll go check on that.
How many do you usually have?
15 on the call.
Yeah. Okay.
So it's kind of strange that nobody's on yet. I think maybe it's a technical thing. Oh, somebody just joined. Hello, Justin. You probably can't hear us yet.
Hola.
Hola. Okay. You are the first person to join, and I told Dave, hey, we're all realtors, which means we all join late. So.
Hey, Justin, how you doing? Good to see you.
Good, how are you?
Good.
So Justin is a very experienced investor as well, does a lot of flips and rentals and full-time realtor as well. So I'm what I aspire to be Justin in 5 years.
That's good. Yeah, Justin and I have actually met. In fact, we worked with
Drig, right?
The Driggs, yeah, Clay and his mom.
Yeah, we just had a conference call like 2 weeks ago about that.
Yeah. Were you guys able to get figured out what you needed on the ownership?
Yeah, it's funny. They're great people, but they don't. I don't know what the best way to say it. They're just not super gosh, I don't know how to say it, man. They just don't go after like learning and grasping concepts super well.
Yeah, they're not sophisticated.
Yeah, that is a good one. Yeah, so I try to like help them along without doing it for them because I don't want to like the liability, you know?
Yeah, I understand.
Yeah.
So, well, hopefully they'll make some good decisions.
Yeah, no, they are. They are.
Great. I'm glad.
So what are we doing today?
I was going to say, I'm going to give people 1 minute and then we're going to start talking about probate. So I'm surprised that no one's really here yet. I was just telling Dave, like, people normally show up a little bit late, but I've never had just one person join. So,
Well, hey, if it's just us, we can talk for a few minutes about probate. I can show you guys some pictures and slides if you want.
Yeah, let's do it.
I know a ton about probate. So, oh, looks like somebody else is just joining here. Welcome, whoever joined by phone. If you would like to introduce yourself, that'd be great.
Hi, Alan. It's just Lynette and Ashley. We're just confirming that this was the right link. I can't hear him.
So, yeah, let's dig in. So, like, my experience with probate is very limited. So, I mean, I'm really interested in what you have to say because I've never really dealt with it before.
Okay. Well, let me run the little presentation for you guys. It's not long. It's just about a dozen slides or so, and we can just, if it prompts some questions, we want to have conversation, feel free to chime in and ask a question or
Are you able to
comment
access?
at any time. All right, so let me share my screen here. And let's see, Alan, you might have to allow me to share.
Look at that 1 second. Oh, Ashley, you're gonna need to promote him as a panelist so that he can share his screen. If you're back at your desk yet, you might still be up front, but we need you to do that. Hello, Ashley? Maybe in transit. There we go.
Oh,
Hey,
there
I
we go.
just got back. I just made him a host so that he can do that.
Okay, yeah, I see that. Thanks, Ashley. So, all right, you see the real estate and probate slide? Great. Okay, so we're going to talk about how to deal with a house that's in probate or is about to go through probate or is coming out of probate, that kind of thing. And here's my mandatory disclaimer that every attorney, yeah, whatever. So there you go. So there's some concepts. You're probably familiar with these, so I apologize if I'm sharing information you guys already know, but it's always good to have a refresher. And it even helps me to go through this. So if you pass away without a will or a trust, you die intestate. And there's certain laws that apply to an estate where someone has died intestate. And those laws tell the public and anyone you're related to how your estate is to be distributed, how assets should be divided up and so forth. And it tends to follow this chart. And this, interestingly, is also how the next king or queen of England is determined as well, by following this kind of succession line. And there are basically two systems that different states follow. One's per stirpes, one's per capita. The point here is that in each of these scenarios, the plan is placed or put upon your estate, whether you would want it or not. Just by the simple fact that you did not have a will, you did not have a trust, you didn't instruct the world, the court, the public, how you wanted your assets to be distributed. So instead, this is what the state says will happen. The advantages of having a will versus no will, you get to make decisions as to how your assets are going to be distributed. So, for instance, obviously you get to choose your beneficiaries if you have a will. If you have small kids, a will is the appropriate place to put guardianship directions in there. And you get to select the executor. In Utah, that's the personal representative. But I think most people know that office or title as executor. So the executor is the person who files a petition with the court, says so-and-so has passed away. I've been named in the will as the personal representative, and I'm requesting the court's authority to act as personal representative. You'll notice that person has a will, but we're still having to go through probate. One common misperception that I've found amongst the public is thinking that a will avoids probate. It does not. A will is like having a ticket to get into the probate court. The advantage being that you have indicated what your decisions are and how your estate should be administered, but it's not going to avoid probate. And so it's pretty common for an estate to have to go through probate even if there is a will, if there's not a trust. And probate court is going to definitely cost money, and it's going to take some time. As far as costs go, just so you know, I personally, my firm, Planway Law, we do probates on a fairly consistent basis. We're probably picking up a couple every month. And I charge a minimum $3,000 just to file a petition to get into the probate court. And I know attorneys that are charging more than that. Some will charge less, but then they add on their filing fees and other costs. I don't add any costs. I just charge a flat fee of $3,000. So this is what it will cost for us to get to a court decision giving you authority. And the court will give you what's called letters testamentary or letters of administration. So to get to that point, I charge $3,000, which is fairly standard, but it's expensive. My point is that's the minimum. And if it's contested at all, or if there are issues that come up, it's going to only increase the price from there. So it's not unusual that a case going into probate ends up costing the family anywhere from $5,000 to $10,000. It's going to take time too. Right now, the courts are kind of backed up. It seems like they're always backed up. Everything right now is virtual. We're online, all the hearings, so forth are online. And it's from the time I file a petition until I get a hearing, it's taking 2.5 to 3 months. And then it can, go on from there. So yeah, probate is something that if you can avoid it, I think it is worthwhile to avoid it, but most people don't. And so the Utah law says that if you have real estate or if you have a net worth over $100,000, then that estate will need to go through the probate process if there aren't any other arrangements like a trust that's been set up and assets transferred to the trust. So over $100,000 or real estate. Okay. There's no exception on real estate. Like you could say, well, the real estate's an undeveloped parcel out in Duchesne County that's worth, I don't know, a couple $1,000s or so. Doesn't matter. If there's real estate, it has to go through probate. So the process um, I think I covered most of this as I was chatting with you, but if you have a will, we're asking the court to provide what's called letters testamentary. If there's no will, we're asking the court to give us letters of administration. Whichever it is, we're requesting that the court give authority to that personal representative. Now, once the personal representative has that authority, he or she can do anything really to administer the estate that needs to be done. And they're responsible for, first of all, paying any taxes, any debt. If there's a mortgage on the home, once it's in probate, technically the lender has the authority to initiate a foreclosure. Now, in reality, as long as the mortgage is getting paid, that doesn't happen. A foreclosure doesn't happen. And foreclosures, you guys probably know better than I do, foreclosures take time anyway. And most banks don't want to own a portfolio of homes, although maybe right now they would want to, but usually banks and lenders aren't in the business of holding real estate. And so they'd rather work with a prospective buyer to get title transferred to a new owner as quickly as possible.
Hey,
So the
David,
person, yeah,
I just wanted to make you aware that there's a couple questions in the chat box when you get to it.
okay. Yeah, I don't see the
Thank
chat
you.
box.
Oh, you can't?
now, but, oh, there it is.
You see it?
Oh, yeah, I see from, okay. So Justin asked, is that contested or uncontested fee? Are you ever willing to take your fee at closing if they have a house and the estate peeps have no money? Good questions, Justin. So one thing about probate, I get the short answer is it depends. As any good attorney will tell you, it depends. If there's value in the home, if there's equity in there, then yeah, I'm willing to delay my fee until we can get the home sold. However, I will ask for extra because I don't necessarily like to be the financier behind the probate case. And so instead of charging $3,000, I may say, yeah, I'll postpone getting my fee until the house is sold. But instead of the $3,000, I'm going to charge you $5,000, something like that. So, which I think is reasonable because, that money's never going to go into their pocket and have to come out. It will just come when the house is sold. And I'd essentially have a lien on the property or be in a first or second position on the property as the attorney. And so, yeah, if the case is contested, the cost is going to be higher and potentially it's going to be a lot higher. And just so you're aware too, most contested probate cases are going to mediation. And so what that means is I file a petition for my client, an interested party files an objection or some motion to represent their interest, and the court's looking at that and saying, I'm going to send the parties to mediation to try to resolve the dispute, get things figured out. And mediation, it's not a bad world to live in. It usually works out, but it's not, nor is it my favorite thing to do. So I think in general, attorneys who believe their client's right and the other party's wrong don't like to mediate, because the mediator is going to try to figure out some compromise when you're adamant that your party is absolutely correct. But usually in court cases, the only ones that are really happy with the results are the attorneys anyway, because they're the ones that are getting paid regardless of win or lose. And so in that regard, I think mediation's a good place for all the parties, because there's give and take, and when you're done, everyone feels kind of like, yeah, we got some of what we wanted. We didn't get everything, but we're satisfied. So yeah, probates are going to mediation if they're contested in any reason, for any reason. So the executor is going to have to take care of all those expenses, file a tax return, and then they can start settling the remainder of the estate, selling assets or distributing assets, that sort of thing. So once the executor has that authority, they can deal with the real estate. Now, where the real estate goes depends on what the will says. Most of the time, the will is not going to direct that the house be given to a certain child, but it's going to say, upon my death, I want everything to be distributed equally amongst my heirs or my beneficiaries. So if there are 3 kids, there's 1 house, it's a lot easier for that personal representative to sell the house and divide up money than to divide interest in that house. So usually what's happening is the personal representative is going to sell the property. And obviously that's where a realtor would come into the picture. So knowing what cases are going through probate court could be, I don't know if anyone is tuned in to the probate courts and kind of monitoring that. It's not the easiest thing to do. It is all public, but I don't know if it would be worthwhile. But maybe, it's an idea that maybe someone in your world would be interested in looking at, because there are going to be executors out there that need to do something with properties. So just kind of an FYI. But once they have that authority, they can hire the realtor, list the property, accept offers, counter, do all those sorts of things. And then they can transfer the property. Actually, they transfer it as the personal representative of the estate of John Doe. And that's basically how an executor can manage property, a home. There are a few things to be aware of, some issues that I want to highlight just for a moment. Tenants in common. So you guys are, I'm sure, familiar with different types of property ownership, how you can own real estate. Tenants in common used to be much more common than it is now. Usually spouses will own property as joint tenants unless the property's been transferred to a trust, and then they may own it as co-trustees. But once in a while, maybe with older couples that have had property for a couple of decades or so, you'll find property that is owned as tenant in common. And it doesn't act like a joint tenancy. When one of the owner passes away, the other owner doesn't automatically inherit the entire property. And so when you have a joint or a tenancy in common, you've severed the joint tenancy characteristic of that property. So as a tenant in common, I could sell my half of my home. I could put my half in a trust, and my wife could keep her half however she wants to. It's kind of a mess as far as estate planning goes. So I don't advise having a tenancy in common, but it's one way that, for instance, second marriage couples can transfer their own interests to their kids. So it's kind of an interesting, if you come across one and you have questions about it, you're welcome to reach out to me. We can talk about it. Alan, yes. Is joint tenancy newer than tenants in common? And not that it's newer, but joint tenancy was not the default for spouses until like about 20 years ago. And then Utah passed a statute making joint tenancy for spouses the default. Yeah, and so that's why I say if you have a married couple that's lived in a home or owned a piece of real estate for longer than 20, 25 years, a title search will show that, but it's something to just be aware of. So let's see. One of the things that we're looking to do in the probate process is figure out who has an interest in the property. And this can be a little tricky. So super important to make sure the title search is done and done properly. Because, for instance, I had a client just recently, their father passed away. So I'm helping the kids. Father passed away. They thought, they knew he'd been married a second time after he divorced their mom, but they thought he got a second divorce too. They discovered though that he never got divorced the second time. And he was no longer living with his second spouse. They were still married. It's just they'd separated and she'd gone her way, but no one had ever bothered to get a divorce. And so when the second spouse heard that her husband had passed away, she all of a sudden became interested in what he owned. And so this surprised the kids. They thought they were going to inherit this house free and clear. And suddenly here's another party. And under Utah law, the spouse in a second marriage has a right to $75,000 up front, plus a third of the estate, which meant that these kids, after they paid off the debt, they weren't going to have any money to even pay my fee to do the probate. So something to be aware of. When you file a probate court, notice goes out to the public, and people, when they find out, they come out of the woodwork at times. So it's important to make sure everyone has been noticed that possibly has an interest in the property, so that title can get cleared. And then once everything is good to go, the executor can deal with the property. So another piece of advice I guess I'd give to any realtor who's looking to work with an executor is to make sure all of the homework has been done, that the probate is to the point where the notices have been given and the time period has lapsed for interested parties to file a claim against the estate. So otherwise you could have a mess on your hands. So just to kind of wrap up, preventative measures, best tools for avoiding probate. I personally draft a lot of revocable living trusts, and you guys are familiar with trusts and revocable trusts. Reduces the time and the cost of probate. I mean, it just avoids probate for the most part, as long as the trust is funded. So when we set up a trust, we draft a deed, the owners transfer the home from themselves as joint tenants to themselves as trustees of their revocable trust. Then we get that recorded with the county, and we don't have to worry about the home going through a probate court process. Okay, so it's gonna just save time, money, and probably some family drama too. If the home is in the trust, then there's no issue, or at least it's reduced in likelihood that someone like a spouse that everyone forgot exists comes out of the woodwork and can make a claim, because that trust controls what happens to the house now. It's not Utah law. It's not the default anymore of intestacy law. The trust controls what happens. So you avoid that kind of situation too. So I like revocable trusts. They're fairly easy to establish, and it's very easy for us to get the property into the trust. I don't know if you have a question about it. You're probably familiar with trusts and that. I would think that it would be maybe a value add for the realtor just to say, hey, by the way, now that you guys own this home, you want to talk to an estate attorney and think about putting it into a trust, because otherwise, it's not that you're going to have to go through probate, but whoever your heirs are, they're going to have to go through probate if you haven't done something with it.
So David, can I ask a question and maybe clarify a few things?
Yeah, definitely. In fact, that was my next and last slide. Questions and comments?
Well, just based on, maybe you could go back one slide, because, Alan's
sure.
right. Most of it is joint tenancy, except when you do like a 1031 or you've got multiple different partners, it might be a TIC type thing.
Yeah.
So when you've got a husband and wife with a joint tenancy, that's 100% of title, right? It's just if one passes away, the other one, has 100% of title, right? So the
Yeah.
revocable living trust that you might see on title from time to time is not asset protection. It's just in case that somebody dies, that it doesn't have to go through the probate process, correct?
Yeah, correct. In fact, that's a really important point, Justin. So I'm glad you mentioned that, because there's another misperception out there that if you put your home into a trust, you protect it from creditors. And what the law says about that is that if you still have ownership and you have ownership as trustee, then as far as the creditor is concerned, the creditor can go after that asset, can attach that asset, can put a lien on that asset. So you have to use a different type of trust, an irrevocable trust, to protect your home if you want creditor protection. So yeah, there's basically two types of trust. There's revocable, irrevocable. There are subcategories of each of those. So if you're really concerned about creditor protection, Utah has a statute for what's called the Domestic Asset Protection Trust, a UDAP. So the Domestic Asset Protection Trust is a type of trust where you can still act as trustee, you can still live in your house, enjoy the benefit of that, but you're giving up ownership. You're transferring your home into this type of trust. You're no longer the owner. You can be a co-trustee. You need to have another trustee on there. And if you have a mortgage on that house, then a UDAP is a bad idea, because you transfer ownership, the mortgage company can accelerate the loan on that potentially. Now, will they do that? Well, if you're making the payments faithfully, they may not even know that you've transferred the home to an irrevocable trust. But
Is a better strategy to have an LLC on the property in title and then have the trust own the LLC?
well, it could be, but the one issue with putting your home into the LLC, and then let me say this, and then I'll give you some advice as to what I would recommend and what I've been doing for some clients recently. But if you put your home into an LLC, you can get protection because you have that liability shield, as long as you're respecting the legal requirements of an LLC. However, if you do that, you're changing the ownership again. So potentially a lender could accelerate the note. And then also you get a discount on your real estate taxes, your property taxes every year if it's your primary residence. If you're changing the ownership to another entity, there is a line of thought that you potentially forfeit that discount. There's also another line of thought that you jeopardize your rollover, your IRS rollover, potentially. If it's not yours, it's now an LLC's property. So because of those things, what I've been recommending for clients is to use a different type of irrevocable trust that I've been creating. It's called an irrevocable pure grantor trust. And it doesn't have all of the complexity of the UDAPT. And sorry to get a little technical, but the UDAPT requires that you give notice to creditors anytime you put an asset into the trust. And it requires you have another person as a co-trustee that can't be your spouse. It could be a relative, but the IPUG doesn't have those types of limitations on it. And so I've been using the IPUG trust. And I got this idea from a group of attorneys that I joined up with last year called Lawyers with Purpose. And the head of Lawyers with Purpose, a guy named Dave Zampano, he's been practicing law longer than I have, 35 plus years probably. And he created the IPUG about 15 years ago. And it's held up really well in court. And so it's been gaining some momentum around the country. I don't know of any other attorneys in Utah that are setting up IPUG trusts. There might be one or two, but that's what I'm doing right now. That's what I prefer. So it gives you that extra creditor protection that a revocable trust doesn't have, but it still allows you to keep the home as your primary residence. You're not jeopardizing your property tax advantage as your primary resident or your IRS advantage for their rollover. So,
How does that affect the estate tax step up in basis if, grandma passes away and, how does that work out?
Yeah, so most trusts will accommodate the step up in basis. So any beneficiary of that trust can receive the property at the value it had when the grantor, the last grantor, passed away. So you get that stepped up basis. Now, it kind of depends on what state you're in though, right now. If you're in a common law common law state like California, Idaho, then that can be an issue, the step up basis. But in Utah, it's not an issue. So the trust doesn't create any complexity or problem with getting that stepped up basis.
So maybe I could clarify that. So let's say grandma owes nothing on this property. She dies. At the time, it's worth $800,000 and she gives it to her estate.
Right.
It's now worth $800,000. And if they sell it at $800,000, they would have no taxes to be paid on that.
Yeah, no capital gain because of that stepped up basis. So, and say grandma bought the house for $100,000, 30 years ago, and it sells for $800,000 right after she passes away. So there's $700,000 in capital gain, but because of that stepped up basis rule, no capital gain taxes for the kids. It's a beautiful thing. There's actually a proposal. Well, it's more of a trial balloon that's been floated to either eliminate or put some limitation on the stepped up basis rule, because Congress is just looking for tax revenue. And that would be one area where potentially they could get a lot of revenue, but it would affect so many people adversely that I don't think it will pass. I don't think there's much momentum for it. Because, for a lot of people, the most valuable asset they have is their home. And that might be the only thing other than maybe a checking account or savings account that their kids are going to inherit. And so if Congress started to tax that capital gain, and potentially it looks like they're throwing a tax on dead grandma, and that'd just be bad public relations, I think, across the board. So, but I'm watching that. I know the group of attorneys that monitors tax proposals and things. We've been closely watching to see what Biden is going to eventually propose to Congress. So that's been on the list, but also eliminating 1031s has been discussed, but I don't think there's much momentum for that either.
So I can
Is it
keep
1030?
asking questions, but
Yeah, that's okay.
Alan, we can't hear you. All right, here's my question while Alan gets ready. So as
Okay.
investors or agents, we're always trying to figure out where we can get more probate opportunities. What's a
Yeah.
good source for us to find some of those? And then maybe a second question is, you referenced a property that there was no equity to pay your fee. What do you do in those situations?
Well, in that one, I'll answer the second question first. In that one, the family gave me authority to reach out to the second spouse and just negotiate with her. And over the years, I've kind of learned a few things here and there about negotiating. And so we were able to work a deal where she would receive a pension and a life insurance policy, and leave everything else for the kids. So she didn't take any of the debt, but she was the only one that could get the pension anyway. The kids couldn't have inherited the pension. And so we worked that out, and she ended up being satisfied with that, and the kids were fine. And now they've got me negotiating the debt down as much as possible. So, and they've paid me now too. So I'm happy that they've been able to pay me, and now I just want to get them as happy as possible by negotiating that debt down.
Can you hear me now?
I think so.
Good. Okay, great.
Yeah.
So Jen joined a little bit late, and I wanted to just give her an opportunity to see if there was any questions she had specifically for you while we have you here. She turned off. There she is.
I'm here. No, I mean, not quite yet, just because I came in the middle. I kind of trying to catch up to what you guys are talking about. So I might just have to listen to the recording. I see it's being recorded. So thanks for asking.
No problem, Jeanette. Thanks for joining us. And Justin, on the other part of your question, or your first question there, you were asking like what's the source you can go to for probate information, that kind of thing. And I wish I had a better answer for you, other than the probate records are all public, and you can go to the probate court. I don't know if they have a good online tool right now, but and I haven't really looked at it either. And I apologize. I probably should have looked at that to let you guys know if that would be a viable option for you. But that's where I would go if I wanted to know, how can I get more information on what cases are going through probate and what probate matters may have or may involve real estate. I'm betting that a large percentage will involve real estate. Otherwise, they could do a small estate affidavit and just deal with it that way. And so if there's a probate case, I would guess there's a good chance there's real estate involved. So, but I would go to the probate court and see if, and And by go there, I'd say go online or maybe make a phone call, talk to the clerks. And usually the probate clerks are really helpful if you're really nice to them. And so I have my assistant Elaine call, because everyone likes Elaine. If I call, I'm the grumpy attorney, but if she calls, she's the sweet little lady that is oppressed by the grumpy attorney, and so they'll help her because they feel bad for her. But so I would do that. I'd go to the probate clerk and say, hey, how can we get information on what cases are coming before the court or have been through the court? There's going to be a fee, even though it's all public information, it's not free information. So there'll be a fee, but it's going to be a nominal fee. And so anyway,
So
maybe
Dave,
that
I've got a question.
is worth it. Yeah, Alan.
So just to recap, if you're dealing with a non-contested probate case, given the backup in the court, you're thinking like 3 months minimum. Is that kind of? I mean,
Yeah.
everything's different, but I'm just thinking like, hey, if I come up against somebody where they're dealing with that, like I just want to be able to say, yeah, on average, it takes about 3 months, unless there's creditors and other people that are coming into the picture.
Yeah, and maybe 3 months is a little too long. It's just, there's really no rhyme or reason to it, but I just filed a probate 2 weeks ago. And yesterday we had the hearing. And the judge gave us the order. And so, I mean, that one took literally 2 weeks to get. Now, by the order, I mean, our client is now the official executor or personal representative of that estate. So if she owned a home, and there's not a home in her case, it's just some money. But if she owned a home starting yesterday, well, as soon as we get the written order from the court, she would have the authority to transfer that home to a buyer or list it with an agent. So when I say 3 months, I mean, there's kind of a wide spectrum. It could be a couple weeks. Now that's as quick as I've experienced a hearing to be scheduled and an order to be given. So maybe a month to 3 months is a more reasonable timetable.
Okay, that's good to know. Thank you.
Yeah. Okay. So yeah, if you don't have any other questions or comments or anything else, then Justin, I know you have my contact information. Alan, you already have my contact information. If I can be a resource, and by that I'm being as sincere as I can be. If you have questions and just want to ask a question to a lawyer, I'm happy to send you a reply via email or return a phone call without turning on my stopwatch to bill. I don't bill hourly, by the way. I just charge flat fees for the most part. Some clients I do charge hourly, but for the most part, I just bill flat fees because I don't want to mess around with anytime my client calls having to start the clock and stop it when we hang up. And I just
Do you want to give us your contact information?
Yeah. So my email is david@planrightlaw.com. And I'll give you the office line and I'll give you my cell number too. You guys are welcome to call either one. The office is 801-613-8529. And my cell phone is 801. What is my cell phone number? 801-913-0169. I don't call myself much, so.
David, I do maybe have, and hopefully you haven't covered it, but let's say I wanted to make it easy for anybody in my family after I die. Can you tell me the steps I need to take to you know, where do I start to make
Yeah.
it easiest for them? Just kind of give me a timeline or a step-by-step. You already covered it. Sorry, I'll just watch the video.
No, that's okay. What I recommend, I don't know if you can still see the screen, but if you're looking to avoid probate, so your kids don't have to deal with the mess that comes with that, I think
Yeah.
the best solution, or at least a great solution, is to set up a revocable trust and then transfer the real estate into that trust. And by
Okay.
doing that, you'll at least know the real estate will not have to go through the probate court process. And you can transfer all of your assets to a trust. Personal property, you can just sign an assignment to transfer all your personal property. Bank accounts, investments, those have a few more steps to get those into a trust, but people put those types of assets into trusts all the time. We help do that to the extent we can. Some things that are tax qualified should not go into a trust, but I always think it's a good idea to have the contingent beneficiary be the trust. So maybe the spouse is the primary beneficiary of your IRA or your 401k, and then you name your trust as the secondary beneficiary. So if your spouse passes away and you have little kids, then that money would go into the trust, and then the trustee could control it, could set up inherited IRAs for the kids, manage the money rather than just giving it to them when they turn 18. And then who knows what they do with it. Probably not much good.
And then did you also talk about the steps that need to be taken by the trustee once you are gone?
Once you're gone? Yeah, so the trustee, the beautiful thing about the trust is that as soon as the grantor passes away, the grantor is usually the trustee, right? So I'm the grantor, I set the trust up, and I'm the trustee, so I manage and control the trust. Then when I die, immediately my successor trustees can step into my shoes and becomes trustee. So for example, when my mom passed away about 9 years ago, I was her successor trustee. So I was able to actually contact a realtor and list her home. I accepted the offer that came in, and every document I signed David Wood, trustee, and trustee of the Pat Wood Living Trust, or whatever we called it. When it came time to do the closing at the title company, every document I just signed as David Wood, trustee. And it just made it so smooth and easy to handle the home that way. Does that make sense?
It does, but I feel like you're skipping steps. Don't you have to like get an EIN number and like go through all this other rigmarole?
So potentially you'll need an EIN number, but it kind of depends on how long the trust is going to be open. A final return will need to be filed, but it doesn't necessarily need to have a new EIN unless you're going to have the trust around for more than 9 months, and then you probably should get an EIN. But that's not a difficult step either. You can get an EIN online through the IRS's website. You do have to file a final tax return when someone passes away. The IRS always wants theirs. They don't even send you like a condolences card. They just expect whatever income that person had during the year of their death gets taxed. So yeah, and there are a few things. I mean, the trustee is responsible to give a report to all the beneficiaries. So being a trustee, it's certainly not an honor or a privilege. It's a heavy burden, I think. And so when kids or parents fight over who the trustee should be, I'm always on the side that says, hey, I don't want to be the trustee. let someone else do it. Because it's a lot of work. Yeah, does that answer your question though? I mean, yeah, there are some other things for sure.
Yeah, I think I probably just need to watch the whole thing and maybe even get a one-on-one with you, because I feel like there's still, you mentioned filing things and, filing. So yeah, I've always been confused. I've taken a million of these classes and I can never get it straight. So maybe it's just not that straightforward in the first place.
Well, yeah, I'm happy to have a one-to-one where we can just talk about whatever you want to talk about. We can go to lunch or have a web chat, whatever you want to do. Happy to do that. I eat every day too, by the way. Alan knows I love to eat.
So Dave, thanks so much for joining us. We've got some other folks that are probably going to be jumping on for a noon meeting, but
Okay.
really appreciate you taking the time to explain a lot of this stuff and I, highly recommend Dave. If anybody has any questions, he definitely knows what he's talking about. So.
Well, thanks, guys. Appreciate the opportunity to talk about this kind of stuff. This gets me excited. I know it might put you to sleep, but if you guys were telling me all about realtor stuff, I might yawn a little bit, but I love real estate, so it's good. And you're great at what you do.
Thanks, David. Appreciate your time.
Yeah, thank you.
Yes, thanks so much.
You're welcome. We'll see you.
Bye.